Honorable Owino, I'm sure you'll be able to bear with us. Listen to it also, it is exciting what he's going to say. Then from there we come to you, Honorable Owino. Then we see whether we have time to deal with Honorable Dawood's proposals. All right? Honorable Babu, you'll introduce yourself, introduce whoever you came with, and you go straight to making your proposals in a very abbreviated version, so that we know what it is you're telling us to do. Members of the press, all of you, you're welcome to cover the proceedings so that Kenyans can know what we have before us this morning and how we are going to deal with it. Thank you so much, Honorable Babu. It's your time.
Thank you very much, Chairman. Chairman and members of the committee, good morning.
Good morning.
I'm Babu, Member of Parliament for the East constituency, and I'm here with an amendment bill to amend the Criminal Procedure Code. And Chairman, to give you the background of what I want to amend, just briefly, is that, Chairman, we've had circumstances where Kenyans have been looking for jobs, but they can't get jobs due to the criminal records that's hanging on their shoulders. Chairman, once a member of the society is convicted and a person serves a sentence, either in prison or fined, or both, then Chairman, this person, they are always required, the moment they've cleared the service and they are looking for a job, they're always required to produce a clearance certificate or a certificate of good conduct, which is issued from the Directorate of Criminal Investigation. And then, Chairman, the moment you're issued with this certificate of good conduct, the criminal record always is attached or is part enshrined in this document. So the moment you go look for a job, young men and women in this country, the moment they go look for a job and a criminal record is seen on this document, then that is a ground enough for one not to be admitted, or rather not to qualify for the job. So, Chairman, what I'm trying to amend to include in the Criminal Procedure Code is such that the criminal record of such persons who have served their sentences, or paid the fine or both, should be expunged, and they should now be clean because they have already served, save for some of the offenses like the sexual offenses, Chairman, which are rape, defilement, sodomy, and even incest. And also save for capital offenses like murder, robbery with violence, treason. So, Chairman, that is why I'm here. So I have a document that I will read briefly, and that is the background of what I'm planning to do. And I've been guided by a gentleman and motivated by a gentleman called Ibrahim Kingori Joki, who served for 6 months, having committed a crime, was charged with creating disturbance. And Chairman, this was after 20 years down the line. This gentleman went to look for a job, but could not be given a job because of the criminal record that he had been served for 6 months. So this gentleman did a petition to the court, but the court gave guidance that I will read on what ought to have been done. So you find such a Kenyan who had served and was rehabilitated, because that is the essence of the sentences. So such Kenyan lost a job just because he didn't have a clean record. So, with that as it may, Chairman, I would like to thank you for this opportunity to enable me make my submissions. Number one, summary of the proposed bill. The proposed bill seeks to provide for legal provisions to address the lacuna in the law relating to expunging of criminal records in the interest of justice where police clearance certificates are concerned. Number 2, stipulating the scope of the mandate to expunge criminal records so as to safeguard the same from abuse while creating certainty and uniformity in the manner the procedure is to be applied. The key justification for the bill is to harmonize statute law with the High Court decision in Ibrahim Kingori Njoki versus Directorate of Criminal Investigations versus ECI, the Honorable Attorney General, and the National Transport and Safety Authority. That is the miscellaneous petition 05 of 2020. KEHC 17924, KLR, which raised the urgent need to enact legislation to address the gap in the law with regards to expunging of criminal records. The brief context is that this legislative proposal was conceived from the court's decision in the case of Ibrahim Kingori Njoki versus DCI, the Attorney General, and the National Transport and Safety Authority. The case involved a petition by Ibrahim Kingori Njoki, herein referred to as the petitioner, seeking removal of a 20-year-old conviction for creating disturbance from his police clearance certificate by the DCI. The petitioner sought the same on grounds that the criminal record blocked his employment prospects. He had received a 6-month sentence in 2023 for the said misdemeanor of creating disturbance. The petitioner further referred to a so-called 20-year rule in quotes, after which minimal record should be expunged and thereafter clean police clearance certificates be issued to applicants. In response, the respondents, where the DCI and the AG, relied on Section 55 of the National Police Service Act and argued that records are custodied by the police and only removed where the conviction has been quashed on appeal or revision, hence the current position. They further stated that the so-called 20-year rule referred to in the petitioner's pleadings was discretionary and that they had not elapsed at the time of filing the petition. The court found, among others, this is now the court's decision, that number 1, there is no express legal provision in Kenyan law providing for expungement of criminal records or clear statutory power on which DCI relies to expunge criminal records. This effectively creates a legal gap. Number 2, the court found that the DCI has no clear statutory discretion to delete such records. Existing records can only be altered if a conviction is quashed on appeal or revision. And number 3, the matter was referred to the Attorney General, the Interior Cabinet Secretary, and Parliament for policy and legal action. In terms of the best practice, the court referred to South Africa as having a workable model for expungement of criminal records that Kenya can adopt. South Africa provides a ready template in terms of, number 1, time limits tied to the seriousness of the offense. Number 2, objective eligibility criteria. Number 3, explicit exclusions for offenses such as sexual offenses, that is rape, defilement, sodomy, incest. And number 4, an explicit process including applications, certificates, and regulations. Significance of having expungement laws. Expungement laws are important because they allow certain criminal records to be erased or sealed, giving individuals a fresh start. If enacted, the expungement laws may lead to the following benefits. Number improved employment opportunities. Many employers conduct background checks, and a criminal record can be a major barrier to securing work. Expungement helps reduce this stigma, boosting chances of getting jobs. And number two, second chances for rehabilitation. People who have served their sentence and demonstrated good conduct can move forward without being permanently judged or defined by past mistakes. Number three is social reintegration. It helps reduce the social stigma and discrimination faced by people with criminal records, supporting their integration into the community. Number four, encouragement for law-abiding behavior. The possibility of record clearance can motivate offenders to maintain good behavior and comply with rehabilitation programs. Number five, reduced recidivism. The people can access stable jobs, housing, and community support. They are less likely to reoffend. And lastly, fairness and proportionality. Not all offenses should lead to lifelong consequences. Expungement ensures that minor, outdated, or unjustly recorded offenses do not permanently harm a person's future. In conclusion, Chairman and members of the committee, just like Ibrahim Joki, numerous Kenyan youth suffer from a similar predicament whereby they are unable to secure employment due to their previous convictions and tainted police clearance certificates. This is especially the case where the conviction was as a result of a misdemeanor or a minor offense. Let's give our youth and Kenyans a second chance by considering enactment of this law. Thank you, Chairman.
Thank you very much, Honorable Babu. I think that was conference. We've heard you, members who've looked at the proposed draft, and it is quite exciting, especially for legal academic arguments, so that we are able to understand what we are doing. Let me start you off, Honorable Babu. You've accepted capital offenses, and we know what the capital they carry the death sentence. We're just in the process of reforming the law, so that first and foremost we do away with the death sentence, which means we will not have any capital offenses after that. And we're possibly going to graduate offenses that were capital depending on gravity, degree of involvement in each of them. How will that compare with what you're proposing here? Because if the exemption is not so clear, we will have people entitled to expungement not benefiting from it, because the offense they were charged with is capital, but they served only 5 years. And here it is 10 years, but for capital offenses, no expungement. That's number one. It is in respect of the laws we are just about to amend. So it must be in consonance with what you are proposing here on expungement. I'll come to the second one. So let me hear Honorable Shia. Let me go on to Honorable TJ.
Thank you, Chairman. Thank you, Dr. Babu. I think the amendment makes sense because number one, even God is a God of second chance, and I think it's good that once these people serve their sentence, it should be presumed that they reformed and they've changed, and they should be given a second chance. And also probably applying the principle of double jeopardy, we should not subject these people to double jeopardy, where you serve a sentence, then you continue being condemned even when you are outside. So the person should be given a second chance so that they are able to look for jobs, so that they don't do whatever they need to take them back to jail. I support.
Yeah, Honorable TJ.
My name is TJ Kajuan from Rwanda. Now, I can see that there is a proposal to exempt persons who have been convicted for murder and for sexual offences, if that is the case. But persons convicted for murder and sexual offences will not be eligible for expansion. So why don't you consider everybody else who has been convicted of violent offense, aggravated assault, for example, young people who you actively advocate for, but young people are all over knifing everybody in town. So there is a lot of violent offenses associated with assault. How will these people, because the people that they have assaulted, already their rights have been affected. And if you introduce them to society and you expunge the people that are related to them, it causes a problem for those people who, the victims of assault and violent crimes. That is number one. Number two, the principle of sentencing and the principle of penal conviction, right, must relate to rehabilitation. We cannot presume that people are rehabilitated without evidence of rehabilitation. Why don't you consider a period, say, 2 or 3 years post-sentencing or post-conviction to prove that a person has rehabilitated in fact, and probably even to subject him to institutions that can be proof of his rehabilitation before giving this amnesty, the general amnesty. I agree with you about misdemeanor, small offenses. And I also don't see you touching about juvenile offenses. I would have thought that juvenile offenders would be the ones who would get this automatic exemption. I would expected you to put more emphasis on the juvenile offenders and persons who are minors. But even persons who are minors, upon attaining adulthood, yes, they would be eligible for this. But even then, they must be rehabilitated. Otherwise, we are going to have a lot of young people who continue with their juvenile delinquencies into adulthood.
Okay, thank you. Babu, I think take this over time, just do it to one go. In the exemptions, where do we place terrorism? In modern day society, terrorism is one of those very grievous offenses that are committed, and we need to know whether it can be exempted, or whether it can be exempted, or whether we can have it expunged after the period of sentence is over. Let's also look at financial crimes. It's called Okamla, money laundering, and other related offenses. Some of these offenses, you make hastes of money from dealings in drugs, money laundering, and such other crimes, which on the face of it, possibly nobody would want to forgive you for it. The third one is leadership and integrity offenses. Persons convicted of corruption. We made an effort to try and exempt them. We didn't succeed because we felt corruption is again a very serious offense in the country, and we must be working towards ensuring that the country is ridden off of corrupt practices which are prevalent, which are being mentioned every time, and yet they may actually be part of what is not exempted, such that I serve my many years, and then after that, it's expired, and I'm back to my usual practice without any qualms of remorse. So those three, kindly, you may now respond. Thank you.
Thank you very much, Chairman. Chairman, you raised the issue of the capital offences when you submitted, and you said that why are we considering to exempt other serious offences like death, like capital offences which attract a penalty of a death sentence, that we are working on the amendment of the law, and therefore will do away with the death sentence. Chairman, the moment a person commits crime, there are different types of justice that might be met, or rather, the complainant can seek for different types of justice. Among them being the retributive justice, which involves the punishment or to correct. Some also seek restorative justice, where you may want to restore to the original form, and that is where even the issue of the blood money comes in, depending on different cultures. For example, the Muslims, they would love to solve their murder issues sometimes as a case law by virtue of what we call the blood money, where people agree and they settle the matter out of court. And Chairman, the moment a person commits these offenses, they're always punished through a retributive form of justice where they serve. Be it murder, be it treason, or robbery with violence, or even grievous harm, as my brother the CJ has stated. And the moment they serve, Chairman, you cannot predict, and that is where now we come with an issue where people always think that somebody is a habitual offender. In law, Chairman, because every case must always be treated with its own facts and merits, we will not assume that a person is a habitual offender. And this leads me to a case which was cited in the United Kingdom of John Mills versus the Queen, where this gentleman used to kill children in a bathtub and bury them outside his house. So the moment he used to kill these children, police would come for him and he'd be charged for murder. So he served different sentences for different cases. Then one day, one person committed an offense in a similar way. Then this person, the police went direct to him because the police thought that this type of killing has always been committed by a specific person. So he was arrested, convicted. Then upon appeal, he was released. After being released, the court said that they relied on the contemporaneous similar fact evidence, that the fact that this person has been killing in a specific way and burying in a specific way does not mean that he's the one who killed the other person without proper evidence. So, Chairman, this brings us back to the issue of the habitual offender. And the essence of the service is that you are found guilty and therefore you are being punished and you are done. So if I was just finding that there are certain sensitive cases, and you've added to my list cases like terrorism, but I was reserving that at this particular moment because of what is happening in the country. That's why I didn't want to include it about the nature of the cases that some of our brothers and sisters are facing as of the moment. So if I would have included it, they would have thought that probably, why is Babu trying to bring this into law for us to be punished? That is why I exempted. But serious terrorism cases can be looked into, Chairman, because that is a serious threat. Same for the maandamano terrorism charges. So when it comes to the sexual offences, Chairman, these are very sensitive matters. When we talk about the gender issue, the female, if I would have not included this here, Chairman, as a politician, you would see even people marching here tomorrow saying that why is Babu supporting such offences? So that is why I saw that it's a very sensitive case. And in South Africa, it is one of the cases that has been exempted, that there can be no clearance for that. My brother was in support the principle of double jeopardy, that you don't need to be punished twice. You've already served, you've already cleared yourself, and you having this tag on your back might lead, Chairman, to you even committing more crimes. Because if there is no job and you cannot be accepted into the community, into the society, because of the stigma and the thought that you are forever a criminal, then this person might find a prison a better place to live in and might decide to commit other crimes to go back there. The CJ, Honorable TJ, talked about the same issue of the capital offences and advocates that there are certain cases that can also be added into the list, which I also agree, depending on what the committee will decide. So there are certain cases like grievous harm, but the degree should also be considered, because even a scratch can amount to a grievous harm. But now I think it depends on the degree of the injury that is caused. So I agree with my brother on that. Then I also agree with this proposal that at least the moment you are out, at least a minimum period time should be given so that you are monitored as you integrate into the society. That can even be a 1 or 2 year period to note, because some people might come out but the intention is still to go back. Right? So I agree with my brother. The juvenile offenders should get automatic exemption. I think I also agree with that. So, Chairman, generally, I will stand guided by the committee.
Yes, I think you made it.
Yes.
Those are committee observations which we will also weigh whether we need to include this or not include that. Very important points have been raised, including juvenile offenders, because we must be able to restore those youngsters, and after restoration they have to go and look for jobs, and if they have criminal records hanging over their heads like the sword of Damocles, then we have a problem with that. Okay? I think you've dealt with it well. Thank you so much, Honorable Babu. We will release you so that we listen to Honorable Owino on his proposal, and we will thereafter make a recommendation as to whether this is to be published or not published. If it is published, it will come back to us, and we will now do public participation. Okay, sir? Thank you very much, Honorable Babu. Honorable Owino, it is you now with your proposal on, yours is on parliamentary approvals, what you usually do, the vetting. All right? Thank you. Let's listen to Honorable Owino. Thank you.
Thank you, Chair. My name is Dr. Jambo Funula, and let me also go on record and an alumni of Starehe Boys Center School. So I'm very happy to see the red and blue color behind me. I'm happy, it fills my heart with a lot of joy. Chair, let me start.